Mail and Good morning, everyone. On behalf of Organizing Committee, it's my pleasure to welcome you all to fourth lecture series on research designs and research questions in legal research methodology. We are privileged to have our eminent speaker, Professor Dr. P. Vanangamudi sir, former Vice Chancellor, Tamil Nadu Dr. Ambedkar Law University, to lead today's lecture. I welcome Honorable Dr. Vanangamudi sir and I extend my warm welcome to our Honorable VC, Tamil Nadu Dr. Ambedkar Law University, Colonel Professor N.S. Santosh Kumar sir. Your presence and support are testament to the importance of this lecture series. And a special welcome to our Dean, Professor Dr. V. Balaji sir. And I also welcome Registrar Professor Dr. Gauri Ramesh ma'am, PG Director Professor Dr. Kumararatna ma'am, Faculty Convener Dr. N. Anbarasi ma'am, and all the head of departments, faculty members and students who are present here. It is an incredible opportunity to learn and broaden our perspectives on the topic of legal research methodology. Looking forward for enriching a thoughtful, provoking session. Before we proceed to today's special lecture, let's take a moment to review the key points from our previous session. Sir explained about types of legal education, about subjective and objective research, types of research and level of objectivity, introduction about types of validity, uncovering valuable insights in the legal research. Our sir will guide us through the complexities of research methodology, shielding light on best practices and emerging trends. Over to you, sir.
Sir, please unmute your mic, sir.
Sir, kindly unmute, sir. Sir, kindly unmute, sir.
Now, is it audible?
Yes, sir, you're audible.
Yeah. Good morning to all. It's my pleasure to present this fourth lecture. Before venturing to this lecture, it's my pleasant duty to thank Honorable Vice Chancellor, Colonel Professor Dr. Santosh Kumar, my friend, and other authorities, including the Dean Research, Postgraduate Studies, Undergraduate Studies, and my PhD scholar, Dr. Anbarasi, and those who are assisting her to make this lecture series a successful one. Today's topic of discussion is research design and research questions. The entire research activity, it is to answer research questions. So research design is the overall thing that tries to answer properly in a systematic, concise manner about all the research questions. Therefore, research design, even though it's a broader one, its most important objective is to answer research questions. If you ask whether research question is important or research design is important, research questions are important. It is a research design that enables a researcher to seek reliable, valid, and a proper answer to such research questions. Before going to the definition of research design and helping you to draft research questions, it's my duty to highlight three important points. What are the objectives of or what are the relevance of research design and research methods to master's students, PhD students? In the master's level, I understand you have a research methodology paper. In addition, there is a doctrinal research paper as well as a non-doctrinal research paper. So these three papers, they constitute a core curriculum activities of master's degree. After master's, if anybody is pursuing a PhD course or any other course, research method and research design is very important. Most of the students, they may be venturing to go for a legal profession. In the legal profession, if you are going for a regular practice, there also a type of, I am using the word, a type of applied research is in practice. Some of my students are very popular in corporate companies and law firms doing their services. When you are doing work in a corporate firms or law service or legal professional forums, then the applied research is very important. Therefore, my dear students, research activity, whether it is relevant to all other domains except science or not, it is very much relevant to an advocate, a legal practitioners, as well as for students of law. Therefore, the level you go deep into the research design and how to draft research questions and to select the research type and method, that much you can be clear, that much you can be successful in your professional activities as well as in your personal life activity. I'm using the word life. If you are a systematic researcher, your life will be systematic, happy, and pitfalls, drawbacks, failures will be minimal. Therefore, in this context, my request is try to understand research design, research methods, and others in a deep manner, not only in examination point of view in consideration. My second point I would like to emphasize is, for the past three classes, one way or other, we have been dealing with various types of research, legal research. We have discussed that a pure research is a parallel one is an applied research. There is a doctrinal research, the corresponding one is a non-doctrinal research. So four types of research, pure and applied, doctrinal, non-doctrinal, we have been using. My dear friends, please make it a point. No research is absolutely pure and no research is absolutely applied. No research is absolutely doctrinal and no research is absolutely non-doctrinal, are all relative. When you take a doctrine, when you take a title, every title must have a concept or a set of concepts or more than two concepts. When there are concepts, it is a doctrinal research. Therefore, what is much more important is whether the researcher is confining himself only in analyzing the concept or going beyond the concept. If a researcher categorically says, no, sir, my purpose is only to analyze the concept, go in depth about the concept. I'm not bothering about any other relevant activities or the application or the sequence of this concept, then that person is said to be a pure doctrinal research. My understanding is we are doing more non-doctrinal research than a doctrinal research. What I mean by the word non-doctrinal research, suppose if you take a contract, when we take contract, we are defining contract, we are defining consideration, and not only defining contract and consideration, we are proceeding from that one to other aspects, the non-doctrinal aspects, how contracts are in practice right now. Therefore, my dear students, the second point I would like to emphasize, please make it a point, all the researchers are mingling, all the researchers are relative. It is the aim of the researcher that says, I am more a doctrinal research or I am a more non-doctrinal research, or I can say my research is greatly doctrinal or my research is greatly non-doctrinal. Similarly, If you are objective, if you are not bothering about the utility of your research, there are certain research which are basic. Suppose if you are interested in analyzing whether the ancient Hindu law has rule of law or dharma, whether that dharma and the present rule of law are one and the same or different, in what way it is going to help you right now? If you do it, it is a pure doctrinal research, pure research, not in the utility point of view. Suppose if you go beyond, I am analyzing the present day concept in the name of justice, dharma, other things, then that concept becomes a applied one. The point I'm trying to stress, whether it is pure or applied, doctrinal or non-doctrinal, they are relative. The utility point of view, focus point of view, it is important. Another point before venturing into this topic, I have to emphasize there are two types or methods whereby we are doing research, or sometimes these may be the combination of two. One is top-down model and bottom-up model. We are going to have a detailed discussion in the form of reverse pyramidal model about the top-down model. So top-down model means from a broader area to a particular point, if you're pinpointing, that type of research is a top-down model. Suppose if you are going to a corporate side, corporate company, as an employee, as a researcher or a law officer, you are given a problem. You are expected to solve the problem. There, the problem is given to you, and from that problem, you are going beyond. That is what is called bottom-up model. From that bottom, you are going to generalize and predict things. Therefore, these two are the basic things, whether it is taught in research methodology or not. These are like a web running through the entire thing, top-down model and bottom-up model. When we talk about top-down model, it is a deductive logic. When we talk about bottom-up model, it is an inductive logic. Deductive logic refers to general to particular. From general aspect to particular aspect, if you go, it is a deductive one. And bottom-up model means from a particular thing, if you go broader, it is a bottom-up model, it's an inductive. Most of the sciences, they are inductive, they are bottom-up model. But most of the legal and non-doctrinal in social science, it's top-down model or deductive model. So these things, it is part and parcel of the research methodology we must understand. These are the points I would like to emphasize my master's students and research scholars to follow in your research. Otherwise, you may have a confusion. Now let me go to the topic of the discussion, research design. The first two slides, they are referring to the research design definition and the characteristics. One of the most important scholar I like very much, when I did my first PhD in 1980-85, I relied mainly on this scholar. He is Fred N. Kerlinger. He defines what's meant by research design. Research design is defined as the overall plan. My dear friends, don't afraid of these jugglery of words. These are jargons, but it may be threatening, but it's very simple. Research design is like that. Nowadays, we used to call it colloquially research proposal. Research proposal in a systematic manner, we call it as a research design. So research design, according to Fred and Kerlinger, in his book Foundations of Behavior Research, he defines is the overall plan. When you start a research, you must have a plan, overall plan. Then it must include a structure. Structure here refers to structure of data. What type of data you require to answer your research question. So structure refers to structure of the data that you require to answer your research question. And the strategy. Strategy is the type of the technique. There are two types of techniques. One is data collection technique. Another is a data analyzing technique. So the data collection technique and data analyzing technique, these two techniques are very, very important in every research, whether it's a doctrinal, non-doctrinal, pure or applied, whatever it may be, whether it's a legal research or social-legal research or scientific research, all this research, this strategy are the types of data analyzing technique and data collection techniques are important. So Fred and Kerlinger, he says, research design is the overall plan, structure, strategy of investigation conceived so as to obtain answers to research questions. So research question is our heart. That's the basic thing. That research question is to be answered. For a systematic way of answering that one, and this research design helps us. This overall plan is, it starts with A and ends with Z. Therefore, this research definition of Kerlinger is a very important, relevant one. So another concept is control of variance. I don't like to confuse at present what do you mean by control of variance. We have an opportunity to define this concept subsequently. I'll take it subsequently. So this definition is a very popular definition, relevant definition even for legal research. Then the second definition, it is related to similar definition. I need not go in depth about the definition. It is Bar-Wankar definition, similar to this definition. Second slide, please. Similar to this definition of Fred and Kerlinger, he says research design is the plan, structure and strategy and investigation conducted so as to obtain answer to research question. So whether it is Kerlinger definition or some other definition, all this definition they are pointing out, it is the overall plan or structure and strategy. All these things are related to research design. If you have any doubt, simply keep in mind, when you venture into research, you have an overall plan. What to start, when to start, how to start, where to approach, all these things. This is in a technical jargon, it is refers to research design. Please proceed to the next slide, please. Second point. So, yeah, this is the way the research design refers to the overall strategy that you choose to integrate the different components of the study in the coherent and logical way, thereby ensuring that one will effectively address the research problem. My dear students, you may have a doubt right now. How many research questions may have in a research? In the master's level, we are thinking that we need a lot of research questions. No. You take a simple question, basic question, and you can divide this question into at least half a dozen questions. I have taken several illustrations. As far as law university concerned, for masters, there are 13 branches of masters. I have taken around about 10 questions covering all the 13 branches. I'll explain it subsequently. So don't bother about you have to take a lot of questions to answer. One or two questions, the one or two questions can be divided into so many other questions. Then next slide, please. Yeah. Now, there are two types of research designs. In the pure applied doctrinal, non-doctrinal, and the other day we explained on the basis of objectivity, on the basis of the quantification, research design, research methods are to be designed. There are two types of research design. One is a quantitative research design. Another is a qualitative research design. So research design, if it is the data and the objectives are mainly concentrating on the quantitative. Quantitative means measurable, anything that can be measured, anything that can be in numbers, they are called quantitative. So in quantitative studies includes descriptive, correlational, experimental, and quasi-experimental designs. My dear students, you may have a doubt, sir, it's right, but descriptive research design is it a quantitative or a qualitative? There is a small misunderstanding among scholars. We are saying I am describing. Descriptive here refers to, in statistics, there are two important statistics: descriptive statistics and inferential statistics. And most of the students, by the time you might have come across, descriptive statistics, like if you have a mean, if you have a standard deviation, if you have all these things, mean, mode, other things, then that type of description is called, design is called descriptive research design. So descriptive research design, it is on the base of the numbers. Suppose I am given to understand in Ambedkar Law University, Tamil Nadu Dr. Ambedkar Law University, as there are 13 branches, nearly 250 students are being selected every year, and there are 500 students. If 500 students, if you ask me, what is the main mark secured by students who are admitted in this one, I have to take in LLB courses all the students' average marks into, and thereby I can divide into a mean average marks. So average marks, average quantity marks, which are required for selection, being selected in this one. Qualification is one thing, and the minimum qualification is one thing, and the marks required for selection is another thing. If you go, mean is important, and there may be from branch to branch this mean varies. That variation is called standard deviation, variance or deviation. So it is a part and parcel of descriptive research. There is another research design. I will explain it subsequently in the days to come, all this one elaborately. For a better understanding only, I am pointing out. So correlation, next to research design within the quantitative research design is correlation. Correlation is a very important data analyzing technique. When two variables are there, one is an independent variable, another is a dependent variable. When one increases, if another increase, it's called positive correlation. For instance, when age of person increases, weight of the person increases. When age of the person increases, legal awareness increases. If I say it is a correlation. So correlation, when one variable is related with another variable, one is independent, another is dependent, then it is called correlation. So in research design, descriptive and correlational types are part and parcel of the research design. Then there is the experimental and quasi-experimental design. Already I point out, whenever you come across experimental research design, there must be two groups and there must be two tests. Two groups. The first group is called experimental group. The second group is called controlled group. The experimental group is that group wherein the variable which the researcher wants to test, examine, is allowed to influence. Whereas the controlled group is that group wherein the variable which is experimented is controlled, not allowed. So these are the two groups, experimental and controlled groups. As far as test concerned, before introducing the experimental variable, what is the level? It is called pre-test, and the measurement is pre-test measurement. Then after allowing the influence of the experimental variable, if you measure after some time, then the difference between this and that, it is the impact of that variable. So pre-test and post-test. So experimental group, controlled group, pre-test and post-test, these are two important ones. I'll explain it when we go in depth about the research methodology, research methods. So experimental group is that one. At times it happens that it is not possible to control the variable right from the beginning. It is not at all possible. So, right, what is the present stage? It's what's called ex post facto. Already things happen. Now we started. Therefore, it is what is called quasi-experimental group. Now only we are introducing that one. Now only it is there. From this period onwards, what is this impact? If you study, that's what's called, that group is called quasi-experimental group. Therefore, my dear students, the research design in if it is based on quantitative studies, then the types of research design, it is varying as a descriptive, correlational, experimental, and quasi-experimental. These are the 4 important. Then the next type of research design is a qualitative research design. Please move the slide a little bit. The qualitative research design, there are several qualitative research designs. One is called grounded theory, another is called ethnographic, third is called narrative research, fourth is called historical research, fifth is called case studies, and sixth is called phenomenology. My dear students, don't bother about seriously, but I would like to emphasize only one thing. Case study, we have my experience in the law university. It is it started in the law college in 85 and it goes on for a long time. So 3-4 decades. Most of the students, they understand case study as a case analysis. In qualitative research, case study refers to different thing, and the case analysis, as far as the law concerned, it conveys a different thing. What's the basic difference? Case study method is a very important case qualitative research, wherein a researcher in his research pursuit, if he takes only one unit or only one person or only one institution and goes in depth about that institution, that type of research is called case study method. He is not taking any sample, nothing, only one. He goes in depth about it. That type of research is called case study method. Whereas in law, we are bothering about when I take cases as a source of study, and people used to say it is a case study. No, it's a case analysis from one case to several cases. If you go case analysis. Therefore, in qualitative research, there are various techniques, various methods which are used. I'll have an opportunity to take it elaborately in the days to come. So I don't like to confuse at present. So please make it a point in research methodology, in research design, there is a quantitative research design as well as a qualitative research design. Don't ask me which method is very important. As far as I am concerned, both methods are important. As I am concerned, we are using all the methods. Which method is predominant method in the present context? That's a very important one. So with this, let me wind up the discussion of types of research design as saying that quantitative research design and qualitative research design. Now let me move on to the characteristics of a good research design. What are the characteristics of a good research design? Fred and Kerlinger, once again, I can go to the definition of Fred and Kerlinger. He's a very popular, he's a behavioral researcher, and he says, in a nutshell, he explains it. I'll explain it and I'll go to the 5 important characteristics of research design, good research design. I'm using the word good research design. A proposal is said to be a good proposal. A research design is said to be a good research design. In my understanding is, if you are interested in joining PhD, you are required to submit a proposal. If the research design, if the research proposal is a good proposal, you are a better candidate, you are a better student to be selected. Therefore, the research design is a good research design if it aims the following. As far as Fred and Kerlinger are concerned, he uses the word Max-Minicon principle. What is Max-Minicon principle? Is maximization of the experimental variable. When we come across a quantitative research, there is an experimental variable. As much as possible, you have to maximize the experimental variable. So maximization of experimental variable. Max. Mini means minimization of error variable. It is always possible in measuring the result, measuring the impact of the variables to commit error. So this minimization of errors is inevitable. Therefore, any research design which provides or which aims at minimizing the error variance, that's a good research design. Then the third one is control the extraneous variable. What I mean by this extraneous variable, In research, there are so many variables. These so many variables may influence the particular research in the research design. It is the most important duty of the researcher to control all other variables. He must allow only the experimental variable to influence. Therefore, in this context, when we come across the detailed various methods, I'll explain it. Right now, I think it will serve the purpose. Maximization of the experimental variable, minimization of the error variable, and controlling the extraneous variables. These are Fred and Kerlinger's concept of max-mini-con principle. Whatever be the definition, whoever be the scholar, these are the 5 important characteristics of good research design. Good research design, it gives a direction for the research process. At times I have come across so many research scholars, they may start, sir, I have drafted 3 chapters. That day when he joins the research, they used to say, sir, I drafted these 3 chapters. No, that's not the right thing. You must go in a procedural manner. The research design gives a direction, and it goes and it points out, it guides you to go in a research process in a systematic manner. So good research design gives a good, clear direction. The second aspect of a good research design is it ensures that the data collected is reliable and valid. Reliable data are to be collected, and the data are to be a valid data. So a good research design helps you to collect reliable and valid data. The third important purpose of a good research design is to minimize errors and bias. Bias is inevitable in social legal research. However, it is to be minimized. The concept says minimization of error and minimization of bias. So in data collection and in data analysis, the bias, opportunity of bias, or the inevitable factor of bias is to be minimized. Then the fourth aspect is ensures that the study is ethical and follows the guidelines. So ethical and following the guidelines refers to you must be sincere to the topic. You should not simply bothering about a degree and PhD or something like that. You must be sincere. You must do justice to the topic. You must be a good ethical person in doing research in that one. Then the final important aspect of a good research design is it enables the researcher to draw meaningful and valid conclusion. When there are research questions, the research questions are to be answered. The answers are to be properly deduced. If the conclusions are reliable, then only prediction is possible. In the previous session, I pointed out the objectives of research, the importance of the research, the most important aim of the research is to prediction. Therefore, unless otherwise, the conclusions are not good, having good generalizability and predictability, then that research cannot be a good research. So a good research design, whether it's a qualitative research design or a quantitative research design, if they satisfy all these purposes, then only we can call this research design is a good research design. Therefore, these are the characteristics of a good research design. Then please move on to the next slide. This is the concept that I explained. This is what's called max-mini-con principle of Fred and Kerlinger. Now, I already pointed out the reverse pyramidal model or reverse triangle model, or the deductive logic method, or how to select a topic and how to draw a research problem. This slide was already introduced in the previous lecture, but we did not discuss this one. For an illustration, I have taken this one. As a constitution is the mother of all legal aspects in India, as we are a law-abiding country, rule of law is basic. I have introduced this one as an illustration. I'm sorry, my dear other branch students of master's degree. However, I will have an opportunity to give you topic. So the thing is, when you entered into law college, when you join master's degree, you are very well in law. And once you joined in a constitutional law or a related subject like human rights, you are very much within the constitution. Everybody must be within the constitution. So rule of law, it means that all are equal in the eye of law. Everything shall be done by the due process of law. And law is supreme. That's the implications of rule of law. So in India, constitution is the rule of law. All are under the control of the constitution. Everything shall be under the framework ambit of constitution. So from law, we deduce into constitutional law. From constitutional law, for instance, I am very much interested in fundamental rights. These fundamental rights, it's a very important area. It includes human rights, it includes right to freedom of trade, and it includes criminal law. Almost all the aspects, they are brought under 13 branches can be brought under the fundamental rights. If we take Article 19.1, all the 6 freedoms, it is brought under, or everything is there, including maritime law is there. So fundamental right is narrowed down. For instance, from fundamental right, I have reduced into freedom. So, sir, it's a very difficult to concentrate the entire constitution, even though it has 448 articles. It's not possible for me to concentrate. I am very much interested only in the fundamental rights. In the fundamental rights, even though it starts from Article 12 to 35, ends in 35, I cannot do all these things because it's a very big ocean like Indian Ocean. I want to concentrate in a very small area. I'm interested in freedom. So from freedom article 19, 20, 21, 22, I am bothering about that one. Then it's a freedom. In the freedom, again, it's a very important one. From A.K. Gopalan to till Puttaswamy versus Union of India, one of the largest 9 judges constitutional bench, personal liberty is explained. So I am very much interested because personal liberty is very much important. I am bothering about this personal liberty. My dear students, I would like to explain now this personal liberty. If you look into the preamble, it is very clear, apart from all other things, we the people of India having solemnly resolved to constitute India into a sovereign, socialistic, secular, democratic republic. My dear students, most of the students, we ignore the subsequent point. And to secure all its citizens. In the preamble, it is very clear things are addressed predominantly only for citizens. Therefore, whether all other non-citizens, whether they have all these rights or not, of course, the Supreme Court is traveling beyond certain points in this one and under the ambit of human rights, other things. I'm not here to make any observation on this one. When we talk about personal liberty, it comes under, it is citizenship. Then next to justice, social, economic, political, the very important aspect is liberty. Dear students, make it a point. In the preamble, only the concept liberty is addressed. Liberty of freedom of liberty of thought, expression, belief, faith, and worship. So when we talk about liberty, even the preamble, it contemplates only 5 things. Don't ask me, are there any other thing beyond 5 things? There are certain things which are beyond the 5 things. So personal liberty, it is part of liberty, but all personal liberty will not be included, will not be within this liberty. So liberty is a broader one. Personal liberty is a narrow one. So when I talk about personal liberty, Article 21, as the Article 21, as I said, it's a very single sentence article. Right from 1950 till date, it was not subject to any amendment, and it goes in a negative manner. Certain fundamental rights are positive fundamental rights. This fundamental right is a negative fundamental right in the sense, no person, it starts with no person shall be deprived of his life or personal liberty, except according to the procedure established by law. So, except according to the personal liberty, there they are using the word personal liberty. Therefore, preamble, it is liberty of thought, freedom of thought, expression, belief, faith, and worship. But in 21, it is personal liberty. So I narrowed down whether this 21 in this context. Now, further, I am narrowing down. whether I am bothering about the evolution of personal liberty. The French Revolution 1789 talks about liberty, equality, fraternity. Am I bothering about that? No. I am bothering about the Constitution. I am bothering about the fundamental rights. I am bothering about freedom. I am bothering about personal liberty under the Constitution, in particularly Article 21. Am I bothering about the previous one or not? No. I am bothering about only within the Supreme Court judgments. How the Supreme Court, in its judgments, it interprets it. It interprets the concept personal liberty. That's my concern. So I narrow down further. Once again, I am narrowing down. As on date, my understanding, we have more than 34,000 Supreme Court judgments right from 1950 till this day. But is it possible for a person in the master's degree or in a doctorate degree or postdoctorate degree to read all the 34,000 judgments? It's very, very difficult. One's life is not enough to have a simple reading. I used to say, even most of the people, we don't read the Constitution of India right from V and ends in Tanaris, right from preamble and ending in 12th schedule. So we don't read because we used to say it's a very big, largest constitution in the world. But in this context, is it possible to read all the constitutional bench judgments? No. Now I am confining myself. I am confining only meta-modern approach of the Supreme Court. Now the question it may go, whether the Supreme Court has any traits of meta-modernity in its constitutional bench judgments? That's the question. How it goes? From 2001 onwards, you can go. If you go to the Google search, and that too, thanks to the Chief Justice of India, who ordered to digitize the entire judgments of the Supreme Court. So all the judgments of the Supreme Courts are there. From your room, you can go for the search and you can say meta-modern, whether this word is found in the judgments. If it is found in the judgments, whether it comes in constitutional bench or not. Suppose if it is not coming, does it mean that there is no meta-modern approach? No. The moment when the Supreme Court says it is the judicial process shall be on the basis of this virtual meeting or video conference, filing is on the basis of online filing, when everything is digitized, when we are going online, when we are using the device of internet, it is meta-modern. Therefore, my dear students, it's a wonderful area for legal research scholars. I have a jealousy. If this opportunity is available to me, I will not come to teaching nothing. I would merge my life, dedicate my life only to analyze the entire constitution things. But unfortunately, it's not possible. It was not possible anyway. So let me, for a better understanding of the students of constitutional law and international law and human rights law students, from 1950, if you we have 75 years, around about 75 years of constitutional Supreme Court constitution bench and other things, right from 1950 to 75, 25 years. This period is broadly called as a modern period. From 76 to 2000, another 25 years. It is a post-modern period. From 2001 to till date, whether it's 23 or 24, till date, it's a meta-modern period. So, in this period, I confine my area, I confine my chronological years from 2001 to 2023. So, from 2001 to 2023, how many constitution benches? My understanding last year, 17 constitution bench judgments. Year before last year, it was 4. And before that, it was 3. So from 2001 to till date, how many? You can simply select and you can go for meta-modern approach of the Supreme Court with particular reference to the constitution bench, with particular reference to personal liberty, which comes under freedom, which comes under fundamental right, which comes under constitution, which comes under law. This way you can go. My dear students, whether it is a one PhD topic, my understand 25 persons can do PhD in this one. In this single area, you can do, because meta-modern is not a single concept. Let me tell you one thing. For instance, there is a concept called heterarchy. Hierarchy, equality. Heterarchy is a concept. That means the decentralization of authorities. Decisions are taken not in one point, in different point. If you take, it is meta-modern. If there are any issues or concepts like this, then it's a meta-modern approach. Similarly, polylock. Whenever the Supreme Court Constitution bench, it says, don't come to arbitrary conclusion. Don't simply rely on dialogue. Go for polylock. What I mean by the word polylock, polylock means there may be several persons. It's not a debate. Let us have a common discussion, a dialogue. Out of the dialogue, if there is a common understanding to that particular one, we can follow that one. That is what's called polylock. The meta-modern approach, it refers to polylock. Similarly, there are more than 10 basic concepts in meta-modern approach. Therefore, I can simply say 25 PhDs can be pursued under meta-modern approach within the Constitution bench judgments, all these things. I am pointing out only to say how a concept can be reduced. Let me tell you another thing is, you need not go out from your room, your house, your library. You need not go. Everything is on the table. A click of a button, everything will come. So it's the best way for girl students who are very systematic, who are confined within the house and library. They can do it. It's a very interesting one. It will be a very interesting contribution to legal research. It may be doctrinal and it may also be non-doctrinal. It may be pure. It may be applied. So that way you can deduce this one. So for illustration, I have given this constitutional law topic and I deduce it. I pinpoint, finally I can say, does the Supreme Court has meta-modern approach in its constitutional way of doing things? Simple question. Then I can go for another aspects. So let me explain subsequently this one. Similarly, the same analysis can be pursued in the following way. What are the following ways? These are the following ways in which you can go. Similarly, you can analyze justice, liberty, freedom, equality, human rights. Please proceed to the next one. Net banking, rule of law, meta crisis and climate change, work in online, work from home, accident. I'll explain it in depth about it, because some of the students, they think that we are not concentrating on our aspect. On aspect means various aspects of other branches. See, suppose I am interested in justice. Justice according to law, or justice law according to justice? It's a basic question. It's a jurisprudential question. Whether in India, and the other day, some of our students, they point out Article 142, it points out complete justice. I explained complete justice, what you mean by complete justice. When we say complete justice, whether this complete justice is in accordance with law, or in other words, whether justice is in accordance with the constitutional law, or law is in accordance with the justice. The preamble is very clear. To secure all citizens justice, social, economic, and political. There are other justice which are not included in this constitution. So 3. So Article 142, in my understanding, complete justice cannot travel beyond social, economic, and political. You may ask the question, are there anything beyond the social, economic, political? There are areas. There are areas which are not included in this one. So justice according to law, law according to justice, these are two importance. You can refer Rawls' book on justice, a very important recent book on justice. So he introduced a different concept. Therefore, that way you can take it. So similarly, liberty, I have pointed about liberty. Liberty of thought, expression, belief, faith. So when we talk about this one, Article 2021, 358, 359, all these things can be. Why I am pointing out, there are only two articles which are sacred cow in the Constitution, Article 20 and 21. 20 and 21 cannot be suspended even during national emergency by using Article 359. When national emergency is proclaimed under Article 358, by using Article 359, you can suspend all other fundamental rights except Article 20 and 21. So that way liberty is very important. I understand this is the right scenario, right political context whereby you can analyze liberty, whether this personal liberty is much more important than any other liberty. Similarly, freedom, equality, and the human rights. For instance, let me take equality, human rights. There is a branch called Human Rights you might have come across, there is a Human Rights Act in India, the Human Rights Act of 1993. Section 2D of the Human Rights Act defines human rights means and includes liberty, equality, fraternity, and dignity, which are enumerated in the Constitution and are incorporated in the international covenants and are applicable in the courts of the Indian courts, in the courts of India. This is the definition given to human rights. Please make a critical study whether human rights are wider than the constitutional rights, enumerated constitutional fundamental rights, because here it points out international instruments as per section 2D, and international instruments, it is defined in section 2F of the Human Rights Act. My dear students, I don't know how many of you have gone through these minute details. If you go through it, there is an explanation given to section 3F. International covenants, international instruments does not mean this ICCPR and ICESCR. I think it's not out of place to tell you one thing. India is a very, very significant country in incorporating human rights in the Constitution. The UNO was established in the year 1945. And we began to draft our Constitution right from 1946 onwards, 47 onwards. So, and there is a parallel trend as far as the evolution of human rights by the UNO and the drafting of our Constitution in India. So when Constitution came into force in 1950, the ICCPR, International Covenant on Civil and Political Rights, they are mostly incorporated under the heading Fundamental Rights. The ICESCR, it was incorporated in the name of Directive Principles. So my understanding, no other country in the world have incorporated human rights in the Constitution of India in the form of in their Constitution as it is incorporated in the Constitution of India. So fundamental rights of India and DPSP, they are the replica of these human rights, UDHR. Eleanor Roosevelt, who is one of a very popular member of the human rights, she appreciated and observed all these things. So we are not inferior to any of the countries in human rights. But my dear friends, what is the ground reality? That's very important to observe. I'll take it. If you want to take it, it's an applied research. I'll give an opportunity. I will explain it subsequently. Therefore, the definition of the concept is one thing. That is the spirit of the law. But in practice, my understanding is a country is said to be a developed country if the words of the country's constitution and the reality, if they are somewhat reflecting, if there is a small gap only in the words of the constitution, words of the country, constitution of the country, law, legality of the country, and the practicality of the country, that level indicates the development. If there is a wide gap between the spirit and the reality, then it's a less developed country. So we incorporated all the human rights because in 2006, it is categorically incorporated in the Human Rights Act by making this amendment. Whenever UN General Assembly enacted a particular human rights resolution, and such resolutions, if they are incorporated by the government of India, automatically it comes under the ambit of human rights. It is subject to verification. I have to. So, Indian human rights.
நீங்க தாளே இல்லாத இருக்க சொல்லிடுவாங்க ஜாலியா எடுத்துட்டு வீட்டுல இருக்கும் யோசிக்க வேண்டாமா தப்பு
There is some disturbance. I'm sorry. So, human rights, international law, human rights, constitution, all these things are highly related. Therefore, in this context, you can take. My dear students, some of the students are from maritime law. The maritime law students, please make it a point. So nobody is talking about. I had an opportunity to be a visiting.
Sir, your mic muted, sir. Please switch on your mic, sir.
Yes, sir. Yes, sir.
I'm sorry. It's an accident.
Yes, sir. You're
so-
audible.
Okay. So let me repeat. Maritime students, they are worrying, sir. Nobody is touching this one. Maritime students, please make it a note. India is the country which has an ocean, at least in its name, Indian Ocean. This Indian Ocean is a very important one. It's a warm water ocean. This area is a fertile area, future area for development, marine law, marine trading. Therefore, you have to keep in mind, you have a very good scope. Those students who are doing marine law, maritime law, you have a good opportunity in countries like Singapore and other foreign countries. I'm not saying that you have to go abroad, but you have scope. Second point is, in people from Tamil Nadu, this maritime law is in the gene. What is in the gene? Maritime law, it is based on navy, maritime, navigation. So this navigation, navy, it goes back to the word navai. Navai is the word from which navigation, navy is deduced. Therefore, the only sentence that is found in UNO chart is Yadum Ure Yavarum Kelu. The very popular statement of our Tamil tradition is Thiraigadal Odium Thiraviyam Thedu. Therefore, in the gene, we have this one. I will tell you one important thing. I think it's not out of place. The Madurai MP, Su Venkatesan, has written a book, Velpari. There he has stated one important anecdote. There's a fact. The anecdote goes this way. When in the pre-Sangam period or in the Sangam period, when the traders come to India, particularly the Roman and the Greek traders, Egyptians, when they came, Indian rulers, they wanted to give a gift, very novel gift to them. What is a novel gift? The novel gift is Devangu. It's an animal, rare animal. He used the word Deva Vaku animal. The characteristics of this animal is it always looks in the northern direction. Therefore, in those days, when early traders of this part of the country, maybe Indus Valley civilization people also, when they trade in the high seas, open seas, when it was very difficult in the cloudy day, it's very difficult to find out the position of the stars. This Devangu, it will indicate the northern direction they will trade. Similarly, another bird they used to have, it is this crow, Indian crow. The Indian crow will find out the distance from the sea to shore. That way, therefore, we are mariners, we are traders, maritime law, everything is in our gene, and we have a good opportunity. Therefore, maritime law, you can deduce in what way it is related to that one. My dear students, my basic subject is labor law. I did my research in environmental law and labor law. It is always advisable to give two important area of research in that one. Environmental law, meta-modernity relates to meta-crisis. Climate change, climate crisis is one of the meta-crisis. Therefore, in this context, if you take any research in meta-crisis like climate crisis, it is part and parcel of the current topic. As far as labor law concerned, I have given this one, it's in the slide. Work from home, accident arising out of and in the course of employment. If you take this definition, accident arising out of and in the course of employment, does it mean work from home? So this way, the ambit of research in the meta-modern world is going on expanding. Similarly, if you go for criminality, then the definition of part and parcel of meta-modern criteria. So you can analyze it in this context. Therefore, what I'm trying to say, all the 13 departments, you can pursue research in this area. That does not mean that I am advising you to go for in meta-modernity. Whatever you do research after 2000, one way or other, it is meta-modern. And if you take a particular concept related to that one, you are a currency. You can be encashed wherever you go. So in this context, the business law, the research director is from business law. I could sense his mind voice. No, sir, you did not talk about contracts or business law. Net banking. You can take net banking, online contract. All these things are part and parcel of this one. So what I'm trying to say, you reduce all these one into narrow down and ultimately pinpoint that particular one. If you do it, the research questions can be. So research questions can be drafted. How it is drafted? You reduce into a particular area and then from that you can go. Please go to the next slide. Now it is, as people used to say, WH questions. What, why, and how. WH questions, what, why, and how. Every research question starts with what, or why, or how. So I'm giving a clue. Your research question must have a word like what. For instance, suppose if I'm dealing with say, liberty, personal liberty. What is meant by personal liberty? When you define the concept personal liberty, you can take half dozen or 1 dozen definitions of scholars, and you can do that. And ultimately, you have to operationally redefine. It's not possible to take all the concepts into. You have to reduce into a small one. Operational definition. What is operational definition? I can take an illustration. Suppose I am interested in doing research in this state. If you go state in physics, it refers to solid state, liquid state, gaseous state. If I go psychology, it is altered state, different states of mind, altered state, everything. But I am a student of law. I am a constitutional student. I am trying to define state. Even the term state, it refers differently in different places. In the part 1, it defines in one way. Part 3 and 4, another way. Part 5 in a different way. And in some other part, different way. What is the operational definition of state? What I mean by the word state. If you take the state, you can clearly point out in article 12, the state includes. Therefore, there are 3 important characteristics. One is definition is, what is the definition? When you talk about a concept, it is a concept is the construct of the mind. When I use a particular word, what exactly I mean by that word is to be defined clearly. When you define it, you can add something or you can delete it. That is what's called inclusive definition. And another is called exclusive definition. So inclusive definition, exclusive definition, that is your liberty. Therefore, once if you have taken a concept, you have to define the concept operationally. After defining the concept operationally, you have to go for the linking that one concept with another concept. If you are a pure doctrinal researcher, not bothering about anything, you can confine, I am not at all bothering about anything, I am concentrating only. Even in that concept, historicity will be there. What was originally introduced etymologically, how it was modified, what is the present one. What was article 21 in ADM in A.K. Gopalan case is not in the same in Vanangamudi versus Union of India. It modifies ADM Jabalpur, it's different. Now Putasami, it's a different. So it goes on changing. Therefore, what I'm trying to say, when you take a research, when you take a concept, define the concept, operationally define the concept, link that concept into some other related concept. So what are the operational definitions of the concept and in what way this concept is related to? I think I'm going to confuse you, but it's not a problem. Only confusion will clarify, understand things. So I said concepts can be related. If you relate one concept with another concept, it is called a proposition. We can call it a hypothetical proposition. So proposition refers to a statement. In that statement, there are 2 or more concepts which are logically arranged, which convey a particular meaning that may be logically arranged on the basis of deductive or inductive logic. But the most important point is it conveys a particular systematic meaning. But the $1,000,000 question in law university research methodologies, whether hypothesis and this proposition are one and the same. Once again, I pointed out earlier, let me reiterate the point. Propositions may be converted into hypothesis or need not be converted into hypothesis. Propositions, when they are confined only as a concept, construct of the mind, it is a proposition. From the concept, if it is possible to go further and deduce, frame variables, independent variable and dependent variable, then you can go for hypothesis. So hypothesis refers to the minimum 2 variables Variables, what is a variable? Variable is anything that varies from time to time, place to place, person to person. That is what's called variable. So independent variable and dependent variable. If these two things are there, then you can proceed to hypothesis. Hypothesis, it is based on variables. Propositions, they are based on concepts. In research, if it is a pure doctrinal research, hypothesis not required. Propositions, okay. If it is an applied research, you can go for variables hypothesis. If you want to proceed to applied research, non-doctrinal research, you can go with hypothesis. So this is the concept. When we have an opportunity, we'll explain it, elaborate about this one. So research question is that it starts with an interrogative. What's the question? It has an interrogative word. Without interrogative, you cannot call it. That's the difference between objectives and research questions. Objectives are simple statements, hypothetical propositions, whereas research question, it is interrogative sentences. Okay. So number of questions, how many questions one must have? It's the point which can be deliberated subsequently. So please proceed to the next one. Please, next slide. Yeah. See, already I explained. These are the four types of legal research. One is a doctrinal, another is a non-doctrinal. So pure, applied. I said no research is absolutely doctrinal. No research is absolutely non-doctrinal. No research is absolutely pure. No research is absolutely applied. It is depending upon the researcher's objective. You have a concept. Can you imagine any research topic without a concept? Every research topic must have a concept. Can you expect a particular research topic has no use at all? Every research topic and its findings may be somewhat useful. The question is whether it is fully useful or somewhat useful. That's the question. Please proceed to the next one. Slide, next slide. Please, next slide. Yeah, I think these are not my original one. These are taken from what's called the World Justice Project. My dear students, it's a beautiful research area. It has been carried out by the world. It is a World Justice Project. It is based on rule of law. So you go to Google. Our students are very popular, very effective, efficient in using Google. If you go through World Justice Project Rule of Law, all these materials are there. They are doing it every year. They have taken, let me sum up it. The remaining 6-7 slides are related to that one. I have taken only from this World Justice Project Rule of Law thing. They have taken 8 concepts. From these 8 concepts, they quantified. What are the concepts they quantified? They quantified rule of law. They said this is rule of law. It's an operational definition. Rule of law we define in a one particular manner, but this justice project of international researchers, they defined this rule of law in a different context. They have taken 8 concepts, and in the context of 8 concepts, they defined it. They studied throughout the world. Originally, they studied nearly 142 countries. Now it is reduced to 139 countries. So they studied 139 countries. India was also part and parcel of that. With 139 countries, they classified these countries on the basis of economic group, middle income group, developed countries, and low income group. That way they developed on the basis of economic criteria. Similarly, not on the basis of economic criteria alone, region-wise. For instance, India, it is South Asia, SAARC country. 6 countries have been taken. So 6 countries are studied. And as far as this economic criteria concerned, India, it is the middle income group countries. There are 52, 30 35 countries, middle income group countries, 35 countries, they have taken it and they measured it. What I'm trying to point out here is you can do legal research. Any legal research can be a quantitative research. So it is the aim of the researcher. It is the objective of the researcher. It is the researcher's ability. When rule of law is quantifiable, what cannot be quantified? So similarly, if you want to quantify it, you can do it. Another thing. So with these the next 6-7 slides, I can say another 100 students can do doctrinal or non-doctrinal research in your master's degree. At least another 10 PhDs can be done in this one. Again, it is on your desktop on the table. Very useful one. My dear students, already I point out, research is to find out anything new or reject it, or to give a complete comprehensive picture. I don't mean you have to accept this one. You can take an objective. I want to test whether it is a fact, whether it is reliable or not. You reject it. So you need not accept it. Therefore, in this manner, wonderful data bank data, it is related to this one. It is World Justice Project. It goes this way. 8 categories they have selected. It is divided into global rank. India in the global rank overall, it is 79. In the regional rank, was 79 out of 139. India in the region out of 6, it is 3. Income group out of 35, it is 9. Rank range change from from the year 2015 to 2023. Whether we are going up or down, it is pointed out it has gone 3 points down. Therefore, from 0.512, we lower down to 0.49. So this way they measured it. The purpose is not to enlighten my students. This is the area. A concept is taken, a pure concept is applied in the global level and it is measured. A doctrinal research is taken and they are applying it in the non-doctrinal manner. Therefore, the first slide, it talks about the overall global condition as far as India is concerned. Please go to the next slide. The second slide, it talks about, see how it has gone down from the year 2015, from the level of 0.512 to the present level of 0.49. It goes down. Then what is the picture? See, they have given it in a picturized form, diagrammatic form. Similarly, now let me go for rule of law is defined on the basis of 8 concepts. Constraints on government powers. Next slide is constraint of government powers. So it is related to liberty. Liberty refers to absence of government control. Freedom refers to absence of restrainment. Therefore, constraints of government. In the global level, India is 52nd place out of 139. In the regional level, out of 6 countries, India is number 1. Out of in the middle income group, out of 35 countries, India is 3. It is given in that picture. Then absence of corruption. It's a very interesting area. You must understand. Please move on to the next slide. Please, next slide, please. Yeah. Absence of corruption. You might have come across. Our position is 0.4, very low. Out of 139 countries, India's position is 95. Out of 6 countries in South Asia, it is 3rd. Out of 35 countries in the economic background, it is 14. Our position is 0.4. It is measured, quantified, and compared. So it's a comparative study. Comparative study is a very interesting research method. So that way. Then the third factor is open government. Open government and restrainment of the constrainment of the government are identical or related concept. So open government, India is a better position, 0.6. Out of 139 countries, India's position is 40. Out of 6 countries in the South Asia, in open government, we are number 1. Out of income group of the 35 countries, India is number 1. So India is better placing in open governance. That's a point to be noted. It's a very interesting area. Why I am pointing out all these things in the doctoral research, in the undergrad, in the post-graduation level or in research level, you can take these data, you can proceed with that one. I want to test it, or you can go with these guidelines. So that point I'm trying to. So next one is fundamental rights. See the point of it is elaborately dealt with. In fundamental rights, in the global rank, out of 139 countries, India's position is 93. In the region, we are talking about we are doing everything. Of the 6 countries, India's position is only 3rd. Sri Lanka and Nepal, they are doing better than India as per this yardstick. And as far as income group concerned, income rank concerned, 35 countries, India's position is 11. So fundamental rights, it's an area. Yes, any student can start with the presumption. It is pointed out by the World Justice Project scheme like this. I want to find out. Or you can say, this is the global, this is the Indian level. So at the macro level, it is a world level. In the meso level, it is Indian level. At the micro level, I want to study in Tamil Nadu. You can do it. It's a micro level analysis. Even the lower micro level, you can go. That way you can do. See, then the 5th concept is order and security. Please move on this next slide. Order and security. In order and security, see, look, India's position is out of 139 country, 121. That means order and security is not proper. The point is 0.6. And regional bank concerned, regional rank concerned, out of 6 countries, 3rd country. Income country is concerned, it is 35-28. So it's India is not that much in a good condition as far as order and security concerned. Once again, what is order? What is security? What is fundamental right? What is restrainment? These are defined. They are defined operationally. For the purpose of the research, they have defined it. You can question it. This operational definition is not relevant. You can go back to some other definition. You can suggest. It's our liberty to do it because liberty, research has given a lot of liberty to us. We can go. And then 6th one is regulatory enforcement. What is the regulatory enforcement? As far as India concerned, 139 countries, regulatory enforcement concerned, 78. All the laws are good in letters, but in practice, it's not. It's not reaching. So the average, the quantity point is 0.48. So regional rank out of 6, it is 3rd. Income rank concerned 35, it is 10. So this regulatory enforcement is the position. Then the 7th one is, please move on to the next one. It's a very important one, interesting one. Civil justice and criminal justice. In rendering civil justice, what is our position? Out of 139 countries, we are in 110. Of 6 countries in the region, we are 3rd. Of 35 countries in the economic group, we are 23. See how they measured it. You can go deep into this, how civil justice is rendered, how civil justice is defined, what is the operational definition you can. Similarly, criminal justice, you can compare civil justice is better or criminal justice. In India, as far as this comparative point concerned, criminal justice 0.39 average, but of the 139 countries, India's position is 86. Of the 6 countries, 3rd. The income group concerned 35, it is 14. So criminal justice, civil justice. Therefore, the rule of law concept, we have been all along defined. All are equal in the eye of law. Everything shall be done by the due process of law. Law is supreme. The World Justice Project, it has taken 8 concepts and operationally defined these 8 concepts as the rule of law in the globe concerned, and it measured and it given in a clear-cut picture. So this way, you can analyze a concept in a non-doctrinal manner. You can analyze a concept in an applied manner. So pure research, applied research, doctrinal research, non-doctrinal research, it depends upon researcher's ability, the researcher purpose to proceed in this context. Therefore, my dear students, these are the very important observations I would like to point out with the reference to research design, research questions. But one point I would like to emphasize, this period time frame, this situation, Ambedkar Law University and the judicial situation, and 34,000 judgments, of which 2,200 constitutional bench judgments, it will create a new revolution if you properly understand these quantitative measures, qualitative measures, you applied all these things, and if you know all these things. Let me give you another important thing. Your purpose is doing research. If you find any difficulty in measuring it, statisticians are there. They will help you. So in research, your idea is important. In research, ethics is important. But using the service of statistician and others, it's not at all prohibited one. It is not at all not at all restricted or avoidable. So you can use it. With this, let me wind up the discussion by saying research design is a research design is a good research design if it is capable of answering research questions effectively, reliably, and validly. These are the points I would like to state in this section. With this, I thank the organizers for giving me the opportunity. If time permits, I am willing to answer your queries. It's a question answer session. Over to you, organizers.
I don't mind. That's fine. Thank you all for your attention and participation throughout the seminar. We hope you find the discussion insightful and valuable. Before we conclude, we would like to open the floor for any questions.
Good morning, sir. This is
Good morning.
from constitutional first year.
Yeah.
So I would like to know how can we approach doctrinal research, whether to answer what is what, because doctrinal research involves more of literary work in which we will be spending more time in library. Can you elaborate on that?
Yeah. So can I give you one doctrinal research topic as you are in the constitutional law?
Yeah, I wanted to. I was thinking of equality, the evolution of equality, and the and resistance
Okay.
equality.
Okay. Let me. You are Mr. Arun, isn't it?
Yes, sir. Yes.
Mr. Arun, there are so many misconceptions about equality. We must understand the Constitution. Constitution, a wonderful Constitution. I used to say Indian Constitution is a successful Constitution. The average age of the global Constitution, mean age of global Constitution is somewhere around 14 years. We sustained for nearly 75 years. That shows 1.24 billion population. Out of the 8 billion population, we constitute 1.24 billion of the global population. Of the 8%, one is an Indian. That is the situation. So in this scenario, Constitution is a mobile Constitution, successful Constitution. Stability is there and it facilitates. First, this is thanks to Baba Sahib Ambedkar and the persons who drafted this Constitution and the persons who are applying this Constitution. Whatever may be the differences, Constitution does wonders. So with this, let me go. What is equality? Can you attain equality? Can you make a male into female? Can you make a aged person to a young person? That is not the objective of equality in the Constitution. What is stated in the preamble? equality of status and opportunity. Whenever possible, you have to provide equality in status, whether it's a male or a female or a third gender, equality, whether aged or young, equality in status. What is meant by status? In rights and liabilities. Status is a concept, it includes four importance: rights, duties, liabilities, and disabilities. So these four concepts, if you take, there shall not be any discrimination arbitrarily. Status. Opportunity. When there is an opportunity, it must be given to all equally. So the Constitution is very categorical. It provides equality of status and opportunity. When you go to Article 14, it clearly states the state, please make it a point, it is confined to state. The state shall not deny to any person equality before law or equal protection of law. In the house, for instance, Arun's house, if Arun has a sister, if the parents, if they are discriminating, oh, Arun can go to college, law college, and this girl should go to engineering, so law should not be. Can it be a discrimination? Can you approach the court of law? It is a state. No. State, operational definition, opportunity. Therefore, in religion, can there be absolute equality? Still, it is going on. The fight is going on. Therefore, we have to understand the state, the equality concept is defined only in a limited. Let me tell you, Arun, at the global level, there is a conflict between equality and liberty. If liberty is given, equality cannot be there. Inequality will come. If everybody is given equality, liberty, inequality will, I will become rich, resourceful. Inequality. So the controversy between equality and liberty, it is going on. If equality is given, universal equality is given, liberty is useless. What you can give you? Therefore, therefore you have to analyze in this context. In the French Revolution, liberty, equality, fraternity. Whether they achieved it? No. In 1793, France became a dictatorship. In 1789, American Constitution declared liberty, equality, fraternity, and pursuit of happiness. Till 1856 or 1860, slavery was there. India was one of the pioneer country in giving voting equality to women. The Magna Carta country, England, it have given voting right to women only later. So what way you are defining equality? Arun, I can explain. Supreme Court's interpretation of equality. Is it a doctrinal research or not? From 1950 to 1975, modern perspective. From 1950 to 2000, postmodern perspective. From 2000 to 2025, meta-modern perspective. Equality interpretation is changing. Laws are constant. Meanings are dynamic. Meanings are going on changing. So it is going that way you have to. Therefore, when you take doctrinal research, you need not bother about its application or its benefit and its relevance in the present. Confine only to the concept. It's the greatest contribution. It will be a greatest contribution. Okay. Thank you for the question.
Thank you, sir.
Sir, good afternoon, sir. This is
Good afternoon.
Vedrukop from first year LLM, Human Rights
Yeah.
Department. Sir,
Okay.
I have a question relating to the types of experimental method, feasibility of experimental method in human rights studies, because the social science variables and phenomena cannot be experimented in a controlled group of settings in most of the cases without giving it artificial nature or biased and stereotypes. Especially, I am now referring to some of the human rights studies conducted in experimental setup,
My
especially
dear
the
student,
recent
can I
reform.
explain one thing? Can I explain one thing?
Yes, sir.
When you say it is not possible, when you say it cannot be, we are not understanding the problem. We are not willing to take the problem. I'll tell you one thing. In the year 1982, 83, when I was doing my first PhD, we have done a research. My friend has done a research. You know the type of research? Fertility behavior of people.
Yes, sir.
Fertility behavior of people, whether it is measurable or not. Behavior, that to fertility is behavior. You have to define operationally what's meant by fertility, what is meant by behavior. If you define within this ambit, you can reduce into. Let me tell you, we put a question whether on this 3 days period, women are allowed to perform these functions. One. So similarly, we framed so many questions and measured it. It is quantified. You know, that time one of a very popular demographer, population studies expert, Professor Chandrasekhar, he was a very popular. Under his study, under him, we have done this work. We can do it. Let me tell you another study, behavioral study, protein consumption and political participation. We measured it. When you say human rights cannot be measured, behavior cannot be measured, means you are not willing to define the concept in such a manner to quantify it.
Yes, sir. But I am afraid that there must be stereotypes or biased in a control group of settings.
So that is your ability to see. If you say these are my limitation, these are my possibilities within this one, I have measured it. Who is going to ask it? You categorically say, I have done this research, I have selected this sample, I have quantified this one, these are the variables, I measured only in this manner. There, without any bias, if you do it, don't influence. That's good research. We have done a lot of research with questions like this. Let me tell you quantitative research. Human rights. See, in India, throughout India, there is a cell called human rights cell. How many cases are filed? What are the various types of cases? See, our law university is a pioneer university. One IPS officer, he has done a research on human rights, more particularly women's right. It is measured. The destination is there. I don't like to tell the name. It is possible. What is not possible? It is possible. But the question is,
Yes, sir.
are you affordable? Are you affordable? Are you willing to take? Can you take it? You can take a small, very small one problem, and you can go deep.
Thank you, sir. Thank you very much.
Impossibility is the word which is to be eliminated from legal research. Okay, thank you.
Thank you, sir. Thank you.
Yeah. You have this. Okay. Good morning, sir. Myself,
Morning.
Rudran.
Rudran.
Yeah, from criminal law department. Yeah, criminal law department.
Yeah.
Sir, actually, having understood various research methods, like it includes doctrinal, non-doctrinal, and sir, we have understood about max, mini, control principles also. And also we understood about the pure research, applied research, and other research methods, different methods actually. How to measure the validity and accuracy of research, having done all these principles and all the research methodologies, how to understand the accuracy of the entire research, sir, in spite of doing the entire thing in a reasonably good manner, sir.
Yeah. My dear student, you are asking a very pertinent question. But the answer is All along, we are dealing with that one. Why do you bother about that? Go systematically. This is the way I am doing it. Validity, if the data, suppose there is a popular saying, ஒரு பானை சோத்துக்கு ஒரு அரிசி பதம். நீங்க ஒரு பானை சோத்துக்கு ஒரு அரிசி பதம்னு 4 பானையில சோற
Okay, sir.
வச்சுட்டு ஒரு பானையில மட்டும் நீங்க சோத்த நசுக்கி பார்த்தா ப்ரிடிக்ஷன் வருமா? அந்த
Yes, sir.
பானையில உள்ளது அதுதான். So selection of sample.
Okay, sir.
When you select the sample must be a representative sample.
Okay, sir.
So if the sample
Yes,
is not a representative sample, it will not reflect the population. That's what's
Okay,
called
sir. Okay.
intrinsic validity. It must replicate the population. So second one is, suppose criminality. If you are trying to ask the question criminality, your
Yes, sir.
question, if it is not related to criminality, if it is related to some other sentimental thing. So framing
Okay,
the
sir.
question, sampling, everything is a meticulous one. Research design is that which must say what ought to be the sample, what ought to be the
Okay,
set
sir.
of questions, what ought to be. Suppose if you say, I know in law university, we are using 3-point scale, 5-point scale, 7-point scale. Finally, what is a fifth point to one person? It is a third point to another person. It is a seventh point to some other person. Will it reflect? It is your duty to ascertain clearly whether it is a third
Sir.
point, 3-point, or 5-point, or 7-point. Quantification. So, understanding research methodology is that which requires dedication, which requires systematic framing of questions. Questionnaire framing is not an easy one, ordinary one. Framing the questions, measuring the questions, quantifying the questions, applying the appropriate technology. Okay, so criminality
Right,
we can, I will tell you, suppose if in the World Justice Project they categorize criminal justice, how is it possible for them to categorize criminal justice? They have taken how many cases are filed, how many cases are disposed. They might have taken about the duration taken. In India, how many cases are disposed? Filing is 1 day and disposal till his death.
Yes, sir.
When there is a death of the person, you might have come across moritur compass or no, extirpate, or what is that legal maxim? Moritur compass, and if the death of the person, the case dies with the death of the person. It goes like that. There must be a clear time framework. Delay of justice, denial of justice more particularly applicable to criminal justice. How long you can delay a particular case? 10 years, 15 years, 20 years? And there is a lower court, appellate court, Supreme Court, all these things. Why speedy justice is very important. Speedy justice is as important as breath. Thank you.
Thank you, sir. Thank you, sir.
Good morning, sir.
Good morning.
Sir, my doubt is, in a doctrinal research, when one chapter relies on statistics, number, or number-based data that is obtained from reliable sources, such as DRI websites, or in case of cases disposed by, number of cases disposed by the National Green Tribunal or Supreme Court, or articles, amount of red sanders that have been illegally trafficked by the DRI, Directorate of Revenue Intelligence, and other UN reports. For example, in the case of endangered species, they have like certain numbers. When that is introduced in a chapter of a doctrinal research, would that part alone, could it be deemed as an empirical study, sir? So can I term it as partially empirical, sir?
Why not? See, qualitative, quantitative, again, it's a relative one. Qualitative and quantitative. My dear student, I thought you are going to ask whether it is reliable or not. I thought of answering it.
Yes, sir, that was very sorry for intervening. So that's my second question.
Yeah.
Are statistics and data that are received that we obtain from online sources like National Crime Record Bureau and cases disposed or pending before the Honorable Supreme Court
Yeah.
or High Courts, are those reliable?
Girls are very
Would it be
sharp
deemed as
nowadays.
primary source of data, sir?
Girls are very sharp nowadays. See, there are two types of sources: primary source, secondary source. At the outset, you say, my research is predominantly on the basis of the primary source, like this. Persons like me, when we infer conclusions, oh, this is a secondary source. To this much I can able to infer. The reliability level may go down. See, let me tell you, the gravity, the theory of gravity, now it is disputed. Science, it is disputed. Even in the physics law of physics, even in the law of chemistry, when laws are dismissed, rejected, there we are in social science. But our point is, we have to clearly say, what is your source? What type of source you have taken? And on the basis, I arrive at the conclusion. Therefore, the examiner or the reader will come to the conclusion this way. Suppose if you are cooking a particular thing, you are saying these are the stuff. Can you able to infer what would be the taste? If chilies are more,
No,
what
sir,
would
not
be the taste of this one? It will be spicy.
spicy.
If I put more sugar in pongal, what would be? It will be. So based on this
Sweet.
one, we can able to guess what type of output, what is the reliability, what's the validity, all these things. So it is pointed out whether it is out and out based on primary data or secondary data. What is a secondary data in one context will be a primary data in another context. When you say, I am out and out relying on constitutional bench judgments on this issue, whether constitutional bench judgment is a primary data or a secondary data. It's a primary
data.
Any researcher who has analyzed on the basis of the constitutional bench, it becomes a secondary data. Therefore, there is no categorical definition of which is primary and which is secondary. It varies from research type to type.
Depends on the cases, sir. All right, sir.
Okay.
Yes, sir.
Have I
Yes, sir.
answered both
Thank you
questions?
so much for your valuable guidance.
Okay, thank you.
Thank you, sir.
Thank you.
Thank you for your questions and contribution. Now it's my pleasure to invite Ms. V. Danya from Business Law Department to deliver the vote of thanks. She will express her gratitude to everyone involved in making this event a success.
As we conclude today's session, I would like to extend my heartfelt gratitude to our esteemed speaker. I would like to thank our eminent speaker, Professor Dr. P. Vanangamudi sir, former Vice Chancellor, Tamil Nadu Dr. Ambedkar Law University, for sharing his invaluable insight and expertise. His contribution have enriched our understanding significantly. Today, sir had given idea about research design and research questions. He had mentioned about the types of methods, that is doctrinal method and non-doctrinal method, and top-down model and bottom-up module. He also stated about the definition of research designs and the types of research designs. He also stated the characteristics of good research designs, where he stated about 5 points, and he also stated about the reverse triangle methods and the concept of heterarchy. He also stated the various model topics and WH questions. I would like to thank our Vice Chancellor, Dr. Professor N.S. Colonel Dr. Professor N.S. Santosh Kumar Sir, Tamil Nadu Dr. Law University, for sharing his unwavering support and leadership. His visions continues to inspire us all. Also extend my appreciation to our registered Professor Dr. Gauri Ramesh ma'am for her commitment to academic excellence and her role in facilitating these discussions. I would also have a special thanks to the Dean of Academics and Research, Dr. V. Balaji sir, for his dedication in organizing this session and for fostering culture of inquiry and innovations. I would like to towards our PG Director, Professor Dr. Kumuda Ratna ma'am, for her unwavering support and guidance throughout this session. I would especially thank our coordinator, Dr. N. Ambarsi ma'am, for her leadership and commitment to. I would like to thank our technical assistant, Mr. Darwin, and electrician, Mr. Kripagaran, for their success in this session. I would like to extend my heartful gratitude towards all the faculty members and the participants online and offline for your active participation and engagement throughout the session. Thank you all for your participation and for making this session a resounding success. We will look forward to your continued support in this upcoming sections. Thank you all and have a nice day.
Yes, sir. Good afternoon, sir. Thank you so much for this blessed day again. It's a blessed day for the entire legal fraternity. And meet you in the next productive session. Thank you, sir.
Thank you. Thank you.